Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Razam Pereira. Well, the Pinarayi Vijayan-led LDF government in Kerala on Tuesday moved the Supreme Court against the Citizenship Amendment Act, a first by any state government. They sought that the act be declared as violative of the basic structure, principle of equality, freedom and secularism. The Kerala Assembly was also the first in the country to pass a resolution against the act. The CAA grants Indian citizenship to non-Muslim minorities who migrated to India from Afghanistan, Pakistan and Bangladesh following persecution over their faith. Now, the Kerala government has said in its suit that there is no rationale in grouping together the three countries for the purpose of the CAA. In its suit, the state referred to Article 131 of the Constitution. On this edition of The Big Picture, we will take a closer look at Article 131 and special powers of the Supreme Court. Joining me on the program today are P.K. Malhotra, former Secretary, Ministry of Law and Justice, Government of India; Satya Prakash, legal editor of the Tribune; and Aishwarya Bhati, advocate of the Supreme Court. Thank you to all my guests for joining me on this edition of The Big Picture. Aishwarya Bhati, let me begin the program with you. First, let's try and put into perspective and understand what Article 131 is that the Kerala government has decided to invoke to challenge the constitutionality of the CAA.
So, Article 131 is the original jurisdiction of the Supreme Court. It provides that if there is any dispute between one or more states on one side, one or more states on another side, or there is a dispute between states on one side, one or more states on one side, or union on one side, with regard to any law point, any question of fact which turns on a legal issue, then they can come directly to the Supreme Court. Otherwise, all other suits, High Court is the petition for, or the first the courts of instance are the courts for suits to be filed. It's only between the states and union that this is available. But I should also add that this, this does not deal with, actually there is part 11 of the Constitution which deals with the division of legislative work between the union and the states, and it is very clearly defined in 7th schedule of the Constitution as to what will be the list under which the union can make a law, the parliament can make a law, which is the list under which, what are the subject matters on which the state can make a law, and the concurrent. Now in the union list, citizenship is there, that union is empowered to make a law. So to the best of my understanding as a student of law, I think it is a misconceived petition.
Okay, all right. Satya Prakash, are there any conditions, any criterion for a state to file an original suit in the Supreme Court?
No, as Aishwarya has already pointed out, it's just the question of fact or question of law. If there are any, then and between two states, two or more states, or states on the one side, or one state on one side, center on the other, then it can be filed. And Supreme Court has original jurisdiction in these matters. In fact, Supreme Court has basically three kinds of jurisdiction. One is original jurisdiction, 131, then 131 plus advisory jurisdiction under 143, and then this is appellate jurisdiction. There are appellate jurisdiction in civil and criminal matters. Apart from that, they also have contempt jurisdiction. But here, the real question is not whether a state government can file a petition in the Supreme Court relating to such issues. The real question is whether they can challenge a law enacted by Parliament under Article 131. That's the real question. In fact, I can recollect in 2017, the West Bengal government had filed a petition in the Supreme Court challenging the validity of Aadhaar Act, and they had invoked Article 32. And the Supreme Court asked that, does a state government have fundamental rights? Because Article 32 is available only for enforcement of fundamental rights, and then only you can directly approach the Supreme Court for that. And then the Supreme Court went on to say, if at all the West Bengal government is interested, then Mamata Banerjee, the Chief Minister, should herself file a petition in her personal capacity. But here the states, they have taken, states I am using because it's not just Kerala. Today Chhattisgarh government has also filed a petition challenging
different issue, NIA.
Yeah, validity of NIA Act. Incidentally, the act was enacted in 2008 when the Congress party was in power. Today in Chhattisgarh, Congress party is in power. And I find it completely a political issue, because they are trying to say that laws enacted by Parliament are not applicable to states. There are some nuanced stance they have taken, but that is regarding certain entries in the state list. But so far as Kerala government is concerned, what they have said is that under Article 256, the state government is bound to implement laws enacted by Parliament, and what further they said was that since the law is manifestly arbitrary and unconstitutional, so we find it difficult to, we are not in a position to implement it, and it violates fundamental rights of citizens, blah blah blah. To my understanding, it is not open to states to say that we will not implement the law because it is manifestly arbitrary or unconstitutional, because the constitutionality of a law or otherwise is to be determined by constitutional courts, be it high courts or the Supreme Court, and there are already 60 or more petitions pending in the Supreme Court, and the Supreme Court will take them up. The question is, there is a validity, the presumption of validity in favor of laws enacted by Parliament. Unless and until laws enacted by Parliament have been declared unconstitutional, the states are bound to implement. The Chhattisgarh instance or this instance, both in a way, it's a misconceived notions of federalism.
Okay.
Where the states are trying to somehow, trying to poke their nose into certain areas which are somehow reserved for the center. Here, naturalization and citizenship both are under entry 17 of list 1 of the 7th schedule. So it's a thoroughly, there is no question of legislative incompetence. Parliament is thoroughly competent to enact laws on lists on issues enumerated in list 1 of 7th schedule, and this is under entry 17. In case of Chhattisgarh also, they are saying that because there are certain when NIA acts, they are going into territory of Chhattisgarh, or territorial issues they have raised. It is not about geographical territory, it is about the lists, the subjects which are enumerated in these 3 lists.
Okay.
And I don't know how whether the viewers know it or not, the Union Parliament, it has so much power, not just entry 1, entry 3 also, concurrent list, laws made by Parliament shall override the laws made by the states. Even in entry 2, that is state list, the Parliament can make laws in certain circumstances. When there is president rule, all the legislative powers of the state assemblies are transferred to the Union, that is Parliament. There are certain other circumstances where, supposing Rajya Sabha has passed a resolution by 2/3 majority, in that case, even that case, the Parliament can make laws on subjects enumerated in the state list, and further, if 2 or more states together they pass a resolution, state assemblies, and request the Parliament to make laws, even in that circumstance, Parliament can make laws. Here, unnecessarily, there are certain issues which are political in nature. They should be fighting these issues on political planks, trying to disturb the constitutional balance, taking this kind of stance. It will disturb the federal structure, which the states have been, time and again saying that India is a federal state, and center should be respecting the powers of the state. Here, I find a very interesting thing.
Okay.
As if federalism is just one-way street, where the center has all the obligations, states have none.
Okay, all right, points taken. Mr. Malhotra, how would you read these 2 instances, both the instances raised by Mr. Satya Prakash, Chhattisgarh and Kerala as well, 2 different issues?
Mr. Frank, I think the issue for discussion today is what Article 131 says, more particularly with reference to the petition which has been filed by the Kerala government in the Supreme Court under 131, challenging a central enactment, that is the Citizenship Amendment Act. So first let me talk about Article 131. My understanding is Article 131 is a special jurisdiction of the Supreme Court to entertain a civil dispute between on fulfillment of certain conditions. What are those conditions? Number 1, the provision of Article 131 are subject to other provision of the Constitution. In case there is other remedy provided in the Constitution itself, then probably 131 will not be available. Take for example, if there is a water dispute between two states, there is a separate article, Article 262 dealing with it. Parliament can make a law on that. So that dispute cannot come in 131. So this is subject to provision of other constitution. What are the other conditionalities to be fulfilled under Article 131? The dispute must be between states, two states, or between state and central government, or between central government, state and other states, or between states and central government. So there has to be, it cannot be a state entity. It has to be a state government and the central government. That is one condition. And the most important condition is that it with the dispute must relate to a question of fact or of law relating to legal rights of the parties. Now the question which has now the court will have to decide in this particular case, because what the Kerala government has challenged is the law passed by the parliament. It is not a case that for the first time the state government has filed a civil suit under Article 131 challenging this central law. There have been instances in the past also. For example, West Bengal has challenged a central law with regard to rights in mines.
Coal area.
And probably coal area, and the Supreme Court entered in that under 131, and Supreme Court said that under 131 such a petition can be filed, but the law passed by the parliament was upheld in that case. The question here will be, the petition which has been filed in this particular case, whether it really affects the legal right of the state. What legal right of the state is. Now I am trying to distinguish between the two cases with regard to coal mine earlier. There of course the state has legal right. Here what the Kerala government is alleging is violation of fundamental right. Now government itself is a state entity. If for violation of fundamental right any petition is to be filed, the right remedy is available either to a person or to a citizen under Article 226 or Article 32. Can state say that its legal right has been violated because some fundamental right of some citizen, even if it has been violated, does it give a right to the state? I think the Supreme Court will have to decide this. There have been instances in the past where there has been petitions filed under 131 by state of Karnataka, by state of Bihar, by state of West Bengal on various issues, and in each case the Supreme Court has decided whether any right of the state government, any legal right of the state government, mind it, it has to be a legal right, not a political right. If suppose the government at the center on political issues also passes a law in exercise of its power given to it under the Constitution, does it really violate the legal right of the state? I think that is the issue which the court will have to decide. And as my learned two co-panelists have said, prima facie it looks, probably what the state government is trying to say is that their fundamental right has been violated, which probably apparently doesn't seem to be correct, but since the matter is now before the Supreme Court, whatever arguments come before the Supreme Court will take a call on that and a decision will be.
Okay, Aishwarya Bhati, this brings me to my next question. Now, can the Supreme Court test the validity of law under Article 131?
Well, let me break it down a little. Under the Indian constitutional scheme, the only way that the legality of a law can be challenged is only if the law is contrary to, it violates or contravenes in any way Part 3 of the Constitution. Now, Part 3 of the Constitution is that part of the Constitution which contains fundamental rights. It enumerates all the fundamental rights. So, only way that a law can ever be challenged as unconstitutional is only if it is in violation of Part 3 of the Constitution. Now, Part 3, fundamental rights, like Sir Malhotra sir has rightly put, fundamental rights are rights which are available to citizens and non-citizens. There are a lot of fundamental rights which are available to non-citizens also, but available to citizens and non-citizens persons against the state. These are not rights which are available to state.